Good morning. Happy, what is today, Tuesday? Oh, time flies when you're having fun. Anyway, so yesterday, the 17th, apparently someone by the name of Daniel Clemente, the guy who Chillie assaulted on the street before Chillie ran away like a screaming little sissy from the hat guy. Anyway, Daniel Clemente, I might be mispronouncing his name or misstating his name, filed a request for civil harassment restraining order on Chillie on the 17th. I have verified that there is a case. I've checked the Los Angeles County Superior Court's online case search. There has been a case filed. Now, I've also seen documents or portions of redacted documents that are offered for the proof that this Clemente fella has received a temporary civil harassment restraining order. The way the process works in California for civil harassment restraining orders or for domestic violence restraining orders is you fill out the paperwork. They are judicial counsel forms. They're standard forms. They're mandatory. You could get those online. Judicial counsel form, civil harassment restraining order. There's the request, there's the order, there's the notice of hearing. There's various different forms, but they're all mandatory forms. You just fill them out as PDFs and print them out. So we've seen the forms. Now online, at least the last time I checked, it did not show that any of these documents had been filed. And it didn't show that there was anything in the Register of Actions. The Register of Actions will show like what things have happened in the court. You've probably seen it when I've gone over Earl videos where it'll say, on this date, this was done. On this date, this was done. Like on this date, this was filed. On this date, this was heard. On this date, this order issued. On this date, there was a case management conference, etc. So nothing is showing up yet. Now, again, also in the civil harassment restraining order and the domestic violence restraining order contexts, you file your request for restraining order, and then there's a temporary restraining order form that you file with each of the documents. And the courts generally turn those around within 24 hours or thereabouts. Now, in order to get that temporary restraining order, that's not something the clerk does. So the clerk will take your paperwork and then it goes off to a judge. And how long it takes for the judge to get it and take care of it, that all depends. In my experience, you get them usually the next day. It is unusual, especially on a Monday when there's a lot of things happening on a Monday, for you to go in and get a temporary restraining order, actually get back the physical documents the same day. That's unusual. Because again, it has to go in front of a judge. And despite what some of my viewers think, judges are pretty busy. They got a lot of things to do. Not only do they have to do all the stuff in the courtroom, but they also have to do stuff outside of the courtroom, like reading all the pleadings, especially all the frivolous pleadings that litigants like Chillie decastro like to put out. So that is evidence. It's not 100% certain, but that is evidence that the order is not an actual order, that there has not, that what we have seen as the order is not an order. That's evidence. It's not conclusive, but it's evidence. Further evidence is on the documents that we've seen. Mr. Clemente does not list his address. Now, you're going to say, well, it's a civil harassment restraining order. He doesn't want Chillie to know his address and all this other fun stuff. Well, the problem is that you have to list your address. You have to put an address up there. Now, it could be a post office box. It can be one of those mailbox store places. It doesn't necessarily have to be your address, but you have to put an address on there because, number one, the court has to contact you. Number two, the person that you are seeking the civil harassment restraining order against might want to file something, might want to file a motion or or something. And he would have to serve like his response if he's going to file a response to your request for civil harassment restraining order, which is another judicial counsel form. It's a mandatory form. So if he's going to respond to it, he's going to fill that out. Where does he send it? It's also a California rule of court. I'm going to say it's going to be in the trial court rules. So that's going to be Title II. It's somewhere pretty early on. I'm going to say like Rule 11 or 111 or something like that. It's fairly early on. Pleadings have to have, if you're pro per, your name, your address, and your phone number. You can't just write confidential on it. So there has to, it doesn't have to be your residential address, but you have to give an address where you can accept service of paperwork. And so that not being there, I mean, that could have gotten past the clerk. It could have gotten past the clerk. It could have gotten past the judge. It could happen, but that is evidence that it is not an actual, that it's not the actual temporary restraining order. The notice of hearing typically contains a temporary restraining order in it. So that's evidence. Further evidence, the third piece of evidence that I have seen that makes me believe that it is not the actual notice before hearing that's been signed by the judge that includes temporary restraining orders is that one of the checkboxes that Chillie is supposed to stay away from, he can't go within 100 yards, allegedly, of Mr. Clemente's residence. Now, how is Chillie supposed to know where Clemente's residence is? How is Chillie supposed to know where he's supposed to stay away from? That's a problem. So that would be a due process sort of issue where you're telling him he can't go within 100 feet of a place that he doesn't know where it is. So you can't do that. So those are three pieces of evidence that lead me to believe that there is no current temporary restraining order granted by the judge, at least as of the last time I checked the Superior Court's website, and that was this morning, somewhere around 3 a.m. Could have updated since then. I don't know. So that's some reason to doubt that there actually is a temporary restraining order against Chillie. Now, that temporary restraining order does not become effective until Chillie's been served with it. He has to have notice. He has to have notice before that temporary restraining order comes into effect. So if one of the standard things is that you can't possess firearms, so you have to turn them into a licensed gun dealer, an FFL dealer, or you can give them to someone else for safekeeping, but you can't possess the firearm. It's still yours, but someone else has to have it in their possession where you don't have access to it. That also wouldn't kick in until Chillie has been served. I also want to point out that Chillie did not, despite his offer and despite my acceptance of his offer, for him to send me a copy of the complaint that him and his team were preparing to the state bar. He didn't send it to me, so I can't look at it and laugh with you. I've also not been contacted by the state bar. As of this morning, my license was still valid. I mean, these things all take time, but Chillie's insistence that I am doomed for having used the F word for a bundle of sticks. It's laughable, but it hasn't come to fruition, at least not yet. So I'm holding out hope for you, Chillie, that you get a response back from the California State Bar, and that you have the ball sack, the scrotal integrity to publish it. Let us know how successful you are, and then whine about how they're terrible people who aren't accepting your evidence because you don't know what evidence is or how to present it. Anyway, that's it for today, or at least that's it for now. Thanks for watching. If you've sent me emails, just so you know, I try to respond to emails. I don't always, especially if I don't know what to do with it. But I do read the emails, and I read all the emails. Thank you for watching. Have a great day.